Hello friends. Today in this video I'm going to discuss about what is electronic evidence and what are the peculiarities of electronic evidences, how electronic evidence may be admissible before the court of law, the very important and all disputed issue of section 65B of Indian Evidence Act, how the section 65B statement are drafted, how you can preserve your evidence, and also about the various judgments of Indian 65B statement, and also I'll have a in-depth details on admissibility of a telephone conversations or voice recorder. How come that voice recorder recorded evidence is admissible before the court of law, and what is the law in Indian scenario. This video is meant for the law student, the learned lawyer friends, and for the law enforcement agencies, and also for the common people who are regularly dealing with electronic evidences, and especially for common people who are coming to the local PS for their allegations or their complaint. They are coming with a lot of electronic evidences, and those electronic evidences will never be admissible if the provisions of 65B is not being complied with. So what to do, how the section 65B can be drafted. I have seen in my experience that Indian law expect that somebody will come with a statement, somebody will come with an electronic evidence, will produce the statement under section 65B, and he may be a common person as well, may not be the lawyer or a layman to law. So for him also, he should know what is section 65B, how the section 65B drafted, and what are the law prevailing in India. So friends, please enjoy watching this video. It's a pretty long video, but I'll request you to see till the end of this video, and if you have anything to say, please comment on the video, and also if you like, then like and share the same, and also don't forget to subscribe. It will help you to get the notifications of my newer videos. So please stay connected, stay subscribed, and please watch this video. Hello friends, today our discussion is how to deal with electronic evidence in the courtroom or any other places. Electronic evidence is a huge challenge, is posing a huge challenge throughout the world because the dealing with the electronic evidence is a very tricky thing, and there are a lot of challenges been faced by different stakeholder of the judicial justice system. And the biggest thing is, if you go by the concept of electronic evidence, you'll see that whenever we are receiving an electronic evidence, be in a court or by the investigating agencies, when they are investigating, there is always possibility that they are going to get the evidence in secondary format. And differentiation in our Evidence Act, primarily one is primary evidence and the secondary evidence, and there is always a possibilities that the electronic evidence which is coming up from different forum or different platforms is in the nature of secondary evidence. So the secondary evidence has to be given a status of a primary evidence, and for that reasons, if we go by the basic structure of an evidence, is that evidence must first be relevant, and then the relevant evidence has to be admissible before the court of law. These are the two basic and the most important criteria, and evidence have to pass through. But in electronic evidences, the evidences are in most of the time we see that the evidences are relevant, but the admissibility question is a huge problem. And not only in India, throughout the world judicial system, electronic evidence or admissibility of electronic evidence is a big challenge, and different countries have tried to deal with these issues differently. It's a very new subject. Day by day, new electronic evidences are coming up as a vital or critical evidence to prove a case, and that's why the time is ripe, so that we have a detailed knowledge at least to have a working knowledge, so that not working knowledge or understanding of what is electronic evidence, what are the basic nature of an electronic evidence, how the electronic evidence to be dealt with, and how the electronic evidence to be presented before the court of law, so that the court can rely upon it and pass the judgment or adjudicate the case in real terms. Now, electronic evidence is always susceptible to change, and there are findings to that effect, and I'm going to discuss in my own video today all the relevant judgments of Honorable Apex Court of India and other and different parts of the world, and we'll see how this issue of dealing with the electronic evidence being tackled throughout the world, so that electronic evidence can be made admissible, and we see that today in many of the trials, in many of the cases, and in many type of litigations, the litigant people are coming with lots of electronic evidences, and they want their electronic evidence to be taken so that the truth should come before the court. And electronic evidence has got a huge role to play in place of the direct witnesses, or electronic evidence can play very important and vital documentary evidences. And I'm going to discuss today in light of our Indian Evidence Act and also the Federal Rule of Evidences and other evidences law, how these electronic evidences challenge been tackled throughout the world, including India, and what are the judgments and different interpretations coming up after the Parliament attack or Afsanuddin case and all this. So before coming to the exact wordings of 65B and how the 65B to be drafted, and what are the ingredients of a statement under section 65B will be there, we first understand or should have a basic concept about what is evidence, what is electronic evidence, what is the speciality of electronic evidence, and also in this video I'll going to discuss about the landmark judgments on different interpretations of admissibility of electronic evidence with the help of statement under section 65B of Indian Evidence Act, whether it is a mandatory compulsion or it is otherwise, when it's to be exhibited, whether there is an laxity if the information investigating officer doesn't collect it, can it be admitted at the time of, can it be produced at the time of trial. All these issues are coming up in different judgments and findings of Honorable Apex Court and different Honorable Supreme Court of India and from different High Courts of India. I was going to discuss about this in today's video. Before coming to our general statutes, what the law says and whatever is there, the basic concept of dealing with an electronic evidence throughout these decades are been greatly influenced by the one principle that is called the low-card exchange principle. As per the Wikipedia, in forensic science, low-card exchange principle holds that the perpetrator of a crime will bring something into the crime scene and leave with something from it, and that both can be used as forensic evidence. He formulated the basic principle of forensic science as every contract leaves a trace. So if we go by the low-card exchange principle, that whenever somebody enters into a system, that contract leaves something to the system and taking something from the system. So every contract leaves a trace, and this traceability is the most important thing in today's electronic evidence investigations. And the finest wordings of Mr. Paul L. Kirk is worth mentioning here. And as per him, whenever he states, whatever he touches, whatever he leaves, even unconsciously will serve as a silent witness against him. Not only his fingerprints or his footprints, but his hair, the fibers from his clothes, the glasses he breaks, the tool marks he leaves, the paint he scratches, the blood or semen he deposits or collects. All these and more bear mute witness against him. This is evidence that does not forget. It is not confused by the excitement of the moment. It is not absent because human witnesses are. It is factual evidence, Physical evidence cannot be wrong. It cannot perjure itself. It cannot be wholly absent. Only human failure to find it, study and understand it can diminish its value. What a interesting proposition has been propounded here by Mr. previously by Mr. Lockhart, Edward Lockhart, and Edmund previously by Mr. Lockhart, and then Mr. Kirk. So this may be the foundation stone of evidence, the basic word evidence, and this is also the foundation stone of dealing with the electronic evidence, because every time a person enters into any electronic resource, a website, a page, and wherever he stays and committing a crime, and wherever he logs into and doing crime, he is actually leaving some traces of IP address and other thing into the log of that website. So every time there are some personally identifiable informations along with the IP addresses, and which is actually tagging and connecting the accused with the offense. So today's judiciary is wholeheartedly welcoming the advent of science, and as per the Justice Breyer of the US Supreme Court, once he said that science, in the title Science in the Courtroom, in this age of science, science should expect to find a warm welcome, perhaps a permanent home in our courtrooms. Our decisions should reflect a proper scientific and technical understanding so that the law can respond to the needs of the public. So our judicial system, our all the stakeholders in our judicial systems should be equipped with the latest scientific findings, including the electronic evidences, which is going to help us a lot in doing conscientious justice. As per our Indian Evidence Act, Section 3 has given the basic definitions of what is evidence. And if I go by the amended evidence definitions, that is, which includes the electronic records, all statements which the court permits are required to be made before it by witnesses in relations to matters of fact under inquiry, that is a direct evidence, and we can call it oral evidence, and other than this oral direct evidence, there are documentary evidences which include the electronic records which are produced for the inspection of the court. Such documents are called the documentary evidence. So in our final definitions of what is evidence, and especially apart from the direct oral evidence, electronic evidence is just like a documentary evidence, and it is something which is placed before the court for inspections. So electronic evidence is now universally applied, and if we read the definitions of what is electronic record, data and electronic form in Information Technology Act 2000, which is our Indian cyber law, which is amended in 2008, and we also combine the same definitions with the document as per the Indian Evidence Act. We can it will be crystal clear for us that the computer images, text and sounds and videos, whether on a computer file, blog or website or email, are all documents. So now electronic records or electronic documents has got a universality that which can take in many forms, but at the end of the day, these are all electronic evidences. So welcoming electronic records and evidences. If we go by the Information Technology Act, we'll get a few very important provisions. Among them is Section 3 of Information Technology Act, which speaks about the authentication of electronic records, how the electronic records will be authenticated, and it is in tune with the normal record, the conventional record being authenticated by the signature of the owner, and the same way the electronic records is also been authenticated by imposition of the digital signature or electronic signature of the owner. So how the electronic records will be authenticated is been laid down in Section 3 of Information Technology Act. And in Section 3A, the question of what should be the authentic electronic signature has been resolved, and the exact clear understanding of or the definitions of electronic signature authentications, or how the electronic signature be authenticated, are being laid down in the amended provision of Section 3A of Information Technology Act. Now I come to Section 4 of Information Technology Act. We'll see that Section 4 says about legal recognitions of electronic records. This is absolutely wonderful. These provisions is required to be studied in details, because these provisions of Section 4 has given the universality or universal acceptance of electronic records in the courtroom, and no court says that they will not going to take this evidence as the evidence is in e-form evidence. So Section 4 is actually giving a huge and wholesome recognitions of electronic records in the courtroom or in the eye of the judicial system. And then come the provisions of Section 5, which speaks about the legal recognition of electronic signature. So legal recognition of electronic signature, when and how the electronic signature will be recognized, it is also at par with the our conventional signature, but here is technology is something different. And Section 10A is validity of contracts formed through electronic means. It's a very important provisions, because see, the most primitive statute or a law or an act that we have been given by the British are the Indian Contract Act. And that time electronic evidence is a very old and primitive act, and that time there was no electricity. The question of cyber was not there, question of electronic evidence is also not there. So now if you come to our today's perspective, we'll see that every day hundreds and millions, thousands and 100,000 millions of people are interacting on online. They're entering into contract in the online. They're purchasing something from the e-commerce side. They're entering into agreement. They are doing everything on the virtual world. So what will be the validity of this contract formed through electronic means? That is also another very important issue which has been dealt in by the Section 10A of Information Technology Act, which is an amended provisions. And herein the point is made very clear that see that all the ingredients or any of the ingredient of a contract. See, in formation of a contract there are a lot of ingredients. Say for example, offer, acceptance, considerations, and all these things. If any of the ingredients or all the ingredients are in the electronic forms or electronic or through electronic means, then the agreement or the contract to be enforceable in the court of law. So no court say that it is not enforceable. So that is there in Section 10A of Information Technology Act. Now comes to Section 4 of Information Technology Act, which I previously told that it requires to a detailed study. It says where any law provides that informations or any other matter shall be in writing or in the typewritten or printed form, then notwithstanding anything contained in such law, such requirements shall be deemed to have been satisfied if such information or matter is rendered or made available in an electronic form and accessible so as to be usable for a subsequent reference. Now if we go by wordings of Section 4, we'll see that any law, the stress has to be given to the word where any law. This any law is very interesting. It says that say any law which is coming, which has already been there before the IT Act came into effect, and the laws which have already come from 2000 until then, which will also come in the future dates, all and in all those laws, if there is a provision that anything to be placed as an information before the forums, which may be typewritten or printed form, then notwithstanding anything contained in such law, this requirement may be fulfilled if the same is rendered and made admissible in electronic form. So whatever be laid down in a specific legal statute or a penal statute or whatever the statute, the wording of the statute, the electronic record or electronic form of evidence or electronic form of informations are to be accepted by the courts, and also to be made accessible for future or subsequent reference. Electronic, if you go by some silent features of the nature of electronic evidence, or some silent features of electronic evidence, you'll see that electronic evidence is informations. It is either stored in a standalone device or transmitted through networking resources. Keep it in mind that if you go by the section 79A explanation clause, e-form evidence, we'll find that and if we go by the different statutes worldwide, you'll see that it is not the only electronic evidence or the evidence in electronic form which is important. The most important thing is how the evidence is collected, how the evidence is preserved, and how the evidence is made admissible or bringing before the forum. So these are the basic three steps and electronic evidence should be scanned through so that to see that whether the evidence is complete, it is authentic, it is admissible, it is reliable, and it is relevant. So these are all facts or all ingredients of a perfect admissible electronic evidence is obviously centered through the point is how it is collected and how it is preserved and how it is bringing before the forum. So these are the important things. Now electronic evidence is by its very nature, it's fragile, sensitive, and easily altered if necessary cautions are not maintained. It is we see that years after years, when the electronic evidence are been adduced before the court, the opponent has raised and made this point clear that electronic evidence is fragile and sensitive and easily altered, so court cannot rely on electronic evidences. So this is a normal averment regularly been made by the party in oppositions. So another issue of electronic evidence is that it can easily be altered, damaged, or destroyed by improper handling or improper examinations. So if the investigating agencies not paid proper heed or taken proper caution in dealing with electronic evidence when they are collecting the electronic evidences from the PO or anywhere else, then there is every chance that this improper handling of electronic evidence will result into the destruction of the evidence. So then comes the next challenge. The nature of electronic evidence has posed a huge challenge for its admissibility in the courtroom. So I already discussed about this. Is a huge issue, that admissibility of electronic evidence. Now comes to the point of chain of custody. Chain of custody is nothing but a documentation of how the evidence is collected, preserved, and analyzed, and it is actually a roadmap. A chain of custody is actually a roadmap of electronic evidence which is traveling through various medias and ultimately coming to the court of law. Electronic evidence admissibility and relevancies, that I already discussed, already told that the basic structure, the basic ingredient, the basic characteristics of an admissible evidence or a basic characteristics of an appreciable evidence or acceptable, basic criteria of an acceptable evidence is that it has to be relevant, it has to be admissible. So that point has been clearly observed in Anavar PV versus PK Vasid by and others by the Honorable Supreme Court of India. So the point is that constructions by pleading, proof by evidence. The Apex Court says constructions by pleadings, proof by evidence. What kind of evidence is required? Proof only by relevant and admissible evidence. Genuineness, veracity, or reliability of the evidence is seen by the court only after the stage of relevancy and admissibility. These are some first principle of evidences. So these are the first principle of evidence. So the most important thing you see is the relevancy, and then come the point of admissibility. If we come to the section 59 of Indian Evidence Act, we'll see as per the wording of section 59, proof of facts by oral evidence. All facts except the content of documents or electronic records may be proved by oral evidence. So we can have a clear differentiations of nature of evidence. So evidence may be oral evidence, evidence may be documentary evidence, and one of the documentary evidence is an electronic record. Apart from this electronic record or documents, the direct evidence is to be proved by the oral evidence. So 59 is giving a clear differentiation between oral evidence and the documentary evidence, and within the documentary evidence we have a new advent, that we have the advent of electronic records. Now comes to section 59A. There was a amendment in section 65 because section 65 concerns about the normal documents. It never concerns about the electronic record. So we need a special statute provisions for that, and that's why there was an amendment in Indian Evidence Act, and section 65 is further amended to section 65A and section 65B. Section 65A says that it's a special provision, the special provision as to the evidence relating to electronic records. So 65A giving us a special provisions and relating to electronic records. So it says the content of an electronic record may be proved in accordance with the provision of 65B. So it is actually pointing towards the mandate and rules of 65B, and the most important thing, the most important phrase here is that may be. Now that the law is not by the law is basically the interpretations or evaluation of the interpretations coming years after years. So you see the word maybe was initially interpreted in Afshanuddin case, in famous Parliament attack case, is that that compliance of 65B may not be fatal for an investigating agencies or for a prosecution case. But now after the Bashir judgment came in the year 2014, the 65B compliance has become a mandatory preconditions, and this 65A and 65B and all these compliances the 65B compliance has become a mandatory preconditions, and without this the electronic evidence is inadmissible. Without this, electronic evidence is inadmissible. So that is, we see that a huge shift in the interpretations of the word maybe in read down in section 65A since Parliament attack case till the our 2018 landmark judgment by Honorable Apex Court. I'll discuss all this in our later part in details. What is there in section 65B of Indian Evidence Act? Section 65B subsection B has got a lot of subsections, and as per the subsection 1 we have notwithstanding any, it says notwithstanding anything contained in this act, any information contained in an electronic record which is printed on a paper, stored or recorded or copied in optical or magnetic media produced by a computer shall be, hereinafter referred as a computer output, shall be deemed to be also a document if the conditions mentioned in these sections are satisfied in relation to the informations and computer in questions, and shall be admissible in any proceedings without further proof or production of the original as evidence of any content of an original or of any facts stated therein of which direct evidence would be admissible. So evidence, it is giving a huge relief to the technical difficulties we have throughout our times, because see electronic the chances of getting the original or the evidence, electronic evidence in an original format is always bleak, because see whenever we are making a file, we are saving a file, we are doing something, and there is always possibility that we are saving the file in a hard disk, in an allocated space in hard disks. So the possibility of getting the original is near impossible. So whatever be the nature of evidence, which may be either printed on a paper, it may be stored or recorded or copied in a media, the evidence can come if we follow the mandate of other part and other statement and all this read out in subsection 2 and other part of these sections, these provisions 65B of Indian Evidence Act. Then in place of original, we can come with that evidence that print out that stored, recorded or copied in media, the evidences. So evidence of any content, and that will take the status of an evidence in an original format. So that conditions, and if you go by subsection 2, herein we got the conditions referred to in subsection 1 in respect of a computer output shall be the following, namely So the computer output, how that computer output may be produced, and the conditions is laid down here. So the conditions referred to in subsection 1 in respect of a computer output shall be the following. The computer output containing the information was produced by the computer during the period over which the computer was used regularly used regularly to store or process information for the purposes of any activities regularly carried on over that period by the persons having lawful control over the use of that computer. So it is coming from the computer, and this para number 1 is actually giving us is tagging the evidence with the computer from which it has been downloaded, and that computer was throughout the time under the custody and dominion of a person of any computer regularly carried on over that period by the persons who has a lawful control over the use of the computer. Subsection B. During the said period, information of that kind contained in the electronic record or of the kind from which the information so contained is derived was regularly fed into the computer in the ordinary course of the said activities. This type of evidences are regularly fed into. Throughout the material, subsection C says, throughout the material part of the said period, the computer was operating properly, or if not, then in respect of any period in which it was not operating properly or was not or was out of operations during that part of the period was not such as to affect the electronic record or the accuracy of its contents. And the final and the last para should be there in the 65B statement is that the information contained in electronic record produces or is derived from such information fed into the computer in the ordinary course of the said activities. So these are, if you go by section 65B subsection 2, we'll have subsection small a, small b, small c, small d. All are actually is a ingredient of a statement under section 65B. It should be there in a statement under section 65B. And as per the subsection 3 of 65B, where over any period the function of storing or processing information for the purpose of any activities regularly carried on over that period, as mentioned in clause 1 of subsection 2, was regularly performed by computers, whether by combinations of computers operating over that period or by different computers operating in successions over that period, or by different combinations of computers operating in successions over that period, or in any other manner involving the successive operations over that period in whatever order, or one or more computers and one or more combinations of computers. All the computers used for that purpose during that period shall be treated for the purpose of this section as constituting a single computer, and reference in these sections to a computer shall be construed accordingly. So you see, computers or combinations of computers and whatever be the infrastructure, be it LAN, be it and whatever. So that computers is equivalent to computer when we go to the mandate of section 3. Now, as per subsection 4, in any proceedings where it is desired to give a statement in evidence by virtue of these sections, a certificate doing any of the following things, that is to say, identifying the electronic record containing the statement and describing the manner in which it was produced, giving such particulars of any device involved in productions of that electronic record as may be appropriate for the purpose of showing that the electronic record was produced by a computer, dealing with any of the matter to which the conditions mentioned in subsection 2 relate, and purporting to be signed by a person occupying a responsible official positions in relation to the operations of the relevant device or the management of the relevant activities, whichever is appropriate, shall be evidence of any matter stated in the certificate, and for the purpose of this subsection it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person stating it. So see, 65B is an enabling provisions to state that he is telling it to the best of his knowledge and belief, is not required to import any provisions from the Indian Oath Acts. The 65B statement, 65B, the mandate of 65B contains everything. So you come to the subsection subsection 5. We get, for the purposes of these sections, information shall taken to be supplied to a computer. It is if it is supplied thereto in any appropriate form, and whether it is so supplied directly or with or without the human interventions by means of any appropriate equipment, whether the courses of activities carried on by an any official, information is supplied with a view to its being stored or processed for the purposes of those activities by computer operated otherwise than in the course of those, that information of duly supplied to the computer shall be taken to be supplied to it in the course of those activities. So those activities includes these all things. A computer output shall be taken to have been produced by a computer, whether it was produced by it directly or with or without human interventions by means of any appropriate equipments. For example, so explanations was also given, and for the purpose of this section, any reference to the information being derived from other information shall be a reference to its being derived there from by calculations, comparisons, or any other process. So you see, section 65B. You see, section 65B is a techno-legal provision, and this technical thing is having a huge role when section 65B was drafted, and how the devices to be interpreted, how the device to be tagged with the electronic evidence from which the evidence is coming up, how the computers will be taken as a single computer, all these, and what will be the definition of other parameters clearly laid down in section in the provision of section 65B. So it's a hugely enabling provision. It contains everything, and the urgent need of the hour is to clearly understand between the lines of what is laid down in section 65B and its interpretations, since we are getting it from Parliament Data case till today, and these interpretations will go on. This is so it's a hugely important that we should read, understand, and inculcate the inherent views taken in the techno-legal provisions, that section 65B. Now comes to I have given some of the format of section 65B, which may be of your use in your practical purposes when you're adapting you being a investigating officer. You may be a lawyer, you may be a law student, you may be fighting a case for your client, and you want to have electronic evidence to be produced before the court of law, and in any electronic evidence in any format or in any nature requires the statement under section 65B along with it. And I have given an example where CCTV footage, being an electronic evidence, was given in a compact disc, and though electronic evidence, CCTV footage should be extracted by the forensic expert, because there is a question of imaging or properly imaging, and if the properly imaging is not been made, there is always the probability of the data to be tampered or altered and may not be admissible in the court of law. So this is one of the format I have given, and this is another certificate under section 65B of Indian Evidence Act, and this printout, it was a downloaded copy, and someone has downloaded a printout from the his email page, and that was been ultimate 65B statement was drafted in this way. And the first page, you see that the gaps have been left open for typing the details of the device and other credentials on different situation or case-to-case basis. And another example here, downloaded from some of the documents have been produced along with the statement under section 65B, wherein the downloaded printout was annexed along with this statement under section 65B, and this can be taken as a reference for you. And one thing I should must mention here, that these are only example, and I have drafted these on my own understanding, and you are requested to go through the between the lines of the statement, go to the other interpretations of the judgment in light of section 65B, and in accordance with your requirement, please change the draft or amend the draft, or do the thing as per your requirement. Is another statement been given here. So I've given a lot of examples of how the statement of 65B statement under section 65B looks like, and how it can be drafted. So you can take it as a reference, or you can consult books and other things. And I request you may not to confine yourself within these formats. You should also consult other resources before making your statement tailor-made to your purpose. So then, what should be there in a statement under section 65B of Indian Evidence Act? As per the Bivas Judgment, requirement of section 65B is specifically laid down. What will be there in a statement under section 65B? Under section 65B, section 4 of Indian Evidence Act, if it is desired to give a statement, if it is desired to give a statement in any proceedings pertaining to an electronic record, it is permissible provided the following conditions are satisfied. Number 1, a small a, there must be a certificate which identifies the electronic record containing the statements. So you should have a statement which identifies the electronic record containing the statement. The certificate must describe the manner in which the electronic record was produced. The certificate must furnish the particulars of the device involved in production of that record. The certificate must deal with the applicable conditions mentioned under section 65B subsection 2 of the Evidence Act, and the certificate must be signed by a person occupying a responsible official positions in relation to the operations of the relevant devices. So that is a matter of law. Now, apart from that 65B, there are two more important provisions or amendment been made in Evidence Act, and that is section 88A and section 90A. In section 88A, amended provisions of Indian Evidence Act, we can find that the court may presume that an electronic message forwarded by the originator through an electronic mail server to the addressee to whom the message purports to be addressed corresponds with the message as fed into his computer for transmission, but the court shall not make any presumption as to the persons by whom such message was sent. So the clear understanding or meaning of this provision is that the court may presume that a communications from one node to another node has been communicated from originator to the recipient, but court shall not presume court shall not make any presumption as to the person by whom such message was sent. So this provision is actually differentiating between man and machines in our Indian law, and this provision is giving a very important human touch to the problem with the electronic records. So any message can be sent from an account which is made in your name. Somebody can create an account, and that doesn't mean that you have sent the same messages. And sometimes it may happen that your mail ID hacked, and somebody got access to your mail and started sending this mail to other. And in doing so, if something went from your account to another's account, it doesn't mean there can be any presumption that you have sent that mail. So that's a very important safeguard as against to these flaws in technology. Another section is section 90A, where an electronic record purporting or proved to be 5 years old is produced from any custody which the court in the particular case considers proper. The court may presume that the digital signature which purports to be the digital signature of any particular person was so affixed by him or any person authorized by him in this behalf. So here the presumption is of 5 years, other than the presumption in section 90 of 30 years. Here the presumption is 5 years. Now, the very nature of digital evidence, the most important criticism on digital evidence is that digital evidence can be easily altered. So there are times when when the electronic evidence started to come in different forums in India and other part of the world, primarily in different developed countries of the world. This point was regularly been raised by the person in opposition, that the electronic records which the defendant or the parties are trying to be exhibited may not be reliable, this was the normal of the arguments regularly been taken. But on this perspective, we got a judgment in US versus Bonalo, wherein we got a USA court ruled that the fact that it is the fact that it is possible to alter data contained in a computer is plainly insufficient to establish untrustworthiness. So if we want to prove the trustworthiness of a computer or a data, then the fact that that it is possible to alter the data contained in the computer is not plainly sufficient to establish that it is untrustworthy. So and there are provisions where even to the different courts has gone to that extent that if there is any unreliability and if there is any question of reliance on electronic evidence, and the plea was made that the electronic evidence is being altered, then it is the person who raised this point that the electronic evidence altered, it is his or her duty to prove the same. So it is there. Now come to the evolution of the judgments in accepting electronic evidence and its relevancy and the process of admissibility. There are some judgments in Ram Singh and other versus Colonel Ram Singh. In this case, the Apex Court has relied on some of the foreign judgments, and quoting the same, we're going to find in R versus Maqsood Ali, the court observed that we can see no difference in principle between a tape recording and a photograph. In saying this, we must not be taken as saying that such recordings are admissible, whatever the circumstances, but it does appear to this court wrong to deny to the law of evidence advantages to be gained by new techniques and new devices, provided the accuracy of the recording can be proved and the voices recorded properly identified, provided also that the evidence is relevant and otherwise admissible. We are satisfied that a tape recording is admissible in the evidence. Such evidence should always be regarded with some caution and assessed in light of all the circumstances of each case. There can be no question of laying down an exhaustive set of rules by which the admissibility of such evidence should be judged. So that reliance was placed on this judgment in this Indian judgment. Now, in continuing, in Yusuf Ali, Ismail Nagri versus State of Maharashtra, Honorable Supreme Court observed that if a statement is relevant, an accurate tape record of statement is also relevant and admissible. The time and place and accuracy of the recording must be proved by a competent witness, and the voices must be properly identified. One of the features of magnetic tape recording is the ability to erase and reuse the recording medium. Because of this facility of erasure and reuse, the evidence must be received with caution. The court must be satisfied beyond reasonable doubt that the record has not been tampered with. And that is the basic things, because there is no preservation that electronic evidence may not be admissible. But the most important thing is to see whether there is any tampering with that electronic evidence. And the same the factum is coming up, and that this is the pillar of electronic evidence appreciation, that evidence, it is not the evidence which is the most important, but how the evidence is acquired, how the evidence is preserved, and how the evidence is presented before the court of law is the most crucial thing, because evidence may be tampered within this roadway or within this journey of electronic records, and this roadmap or the journey of electronic records from one point to another is also called the chain of custody. So coming back to our that discussions on the judgment, the Honorable Court further said the tape was not sealed and was kept in the custody of Mahajan. The absence of sealing naturally give rise to the argument that the recording medium might have been tampered with, before it was replayed. So that was observations. And further observations, this Honorable Court judgment has further relied on R.M. Malkani versus State of Maharashtra, wherein it is stated that tape recorded conversation is admissible, provided first the conversation is relevant to the matter in issue. The conversation is relevant to the matters in issue. Secondly, there is identifications of the voice, and thirdly, the accuracy of the tape recorded conversation is proved by eliminating the possibility of erasing the tape recorder. The tape recorded conversation is therefore a relevant fact under Section 8 of Evidence Act and is admissible under Section 7 of Evidence Act. So if you want to take the opportunity or the benefit of Section 7 and 8 of Indian Evidence Act and make the evidence relevant, and to put that evidence in proving something, then we have to see that these safeguards are maintained when the evidence has been procured. In Ram Singh and others versus the same judgment, Honorable Court observed that it is clear from decided cases that tape recorded evidence is admissible, provided the originality and the authenticity of the tape are free from any doubt or free from doubt. In N.C. Ramareddy versus Vivigiri, we find that in the Honorable Court observed the following. Having due regard to the reasons referred to above, it is clear that a previous statement made by a person and recorded on tape can be used not only to corroborate the evidence given by the witness in court, but also to contradict the evidence given before the court, as well as to test the veracity of the witness and also to impeach his impartiality. So this evidence is not only for the person who wants to prove something; it is also for the person in adversary who or the person in opponent who has to disprove the case. So this evidence has got a complete quality to be presented and rebutted whenever it is required. This is one of the previous judgment on dealing with electronic evidences in Indian law, and Honorable Supreme Court in State versus Navjot Sandhu alias Afsan Guru case observed that it may be that the certificate containing the details in subsection 4 of section 65B is not filed in the instant case, but that does not mean that secondary evidence cannot be given, even if the law permits such evidence to be given in the circumstances mentioned in the relevant provisions, namely section 63 and 65. Next, it was contended that the printouts or call records have not been proved in the manner laid down by section 63, 65A and 65B of the Evidence Act. This point has been dealt with while dealing with the case of Abjal, and we have upheld the admissibility and reliability of the call records. In this case, the call records and the electronic evidences were being adduced without the compliance of section 65A and B, especially section 65B. And the Honorable Court, the interpretation of this judgment, Honorable Court observed that non-compliance of 65B is not fatal, and even the court can rely on this evidence. So that is one of the first part of interpretation of section 65A, the maybe clause, which I have already referred. Then he got the Tukaram case. In this case, the Honorable Court observed that in Tukaram case, Honorable Court observed that it is well settled that tape records of speeches are documents as defined in Section 3 of the Evidence Act and stated on no different footing than photographs, and which we also have support in Jiabuddin Burhanuddin Bukhari case. There is also no doubt that the new techniques and devices are the order of the day. Audio and videotape technology has emerged as a powerful medium through which a first-hand information about an event can be gathered and in a given situation may prove to be a crucial piece of evidence. At the same time, with the first development in the electronic techniques, the tape or cassettes are more susceptible to tampering and alterations by transportations, excisions, etc., which may be difficult to detect, and therefore such evidence has to be received with caution, though it would neither be feasible nor advisable to lay down any exhaustive set of rules by which the admissibility of such evidence may be adjudged, but it needs to be emphasized that no rule out the it needs to be emphasized that to rule out the possibility of any kind of tampering with the tape, the standard of proof about its authenticity and accuracy has to be more stringent as compared to other documentary evidences. So that is an important observation by Honorable Apex Court. In the later stage, in 2014, the three-judge bench of Honorable Apex Court, in a very renowned judgment, we are all aware of this judgment, observed the following. Most importantly, such a certificate must accompany the electronic record like computer printout, computer disk, video compact disc, pen drive, etc., pertaining to which a statement is sought to be given in evidence. When the same is produced in evidence, all these safeguards are taken to ensure the source and authenticity, which are the two hallmarks pertaining to electronic record sought to be used as evidence. Electronic records being more susceptible to tampering, alterations, transposition, excisions, etc. Without such safeguard, the whole trial based on proof of electronic records can lead to a travesty of justice. So you see the relevance of 65B. It is actually giving a safeguard, and this safeguard words has been used in this judgment, and the interpretation is very clear that 65B is giving and assuring a safeguard that the evidence was collected, preserved, and presented in a proper form. An electronic record by way of secondary evidence shall not be admitted in evidence unless the requirements under section 65B are satisfied. Thus, in the case of CD, VCD, chip, etc., the same shall be accompanied by the certificate in terms of section 65B obtained at the time of taking the documents, without which the secondary evidence pertaining to that electronic record is inadmissible. In the same judgment in Anwar, the Honorable Court further observed any documentary evidence by way of an electronic record under Evidence Act in view of section 59 and 65A can be proved only in accordance with the procedure prescribed under section 65B. Section 65B deals with the admissibility of the electronic record. The purpose of this provision is to sanctify secondary evidence in electronic form generated by a computer. Thus, notwithstanding anything contained, the Honorable Court further observed, in the Evidence Act, any information contained in an electronic record which is printed on a paper, stored, recorded, or copied in optical or magnetic media produced by a computer shall be deemed to be a document only if the conditions mentioned under subsection 2 are satisfied without further proof or production of the original. The very admissibility of such a document, that is electronic record, which is called an computer output, depends on the satisfaction of the four conditions under section 65B subsection 2, which is the crux of the statement under section 65B. The Honorable Court in the same judgment further observed that proof of electronic record is a special provision introduced by the IT Act, amending various provisions under the Evidence Act. The very caption of Section 65A of the Evidence Act, read with Section 59 and 65B, is sufficient to hold that the special provisions on evidence relating to electronic record shall be governed by the procedure prescribed under Section 65B of the Evidence Act. This is a complete code in itself. Being a special law, the general law under Section 63 and 65 has to yield. So, the Honorable Court further observed in the same judgment that the evidence relating to electronic record, as noted herein before, being a special provision, the general law on secondary evidence under Section 63, read with 65 of Evidence Act, shall yield to the same. Generalia specialibus non derogant. Special law will always prevail over the general law. It appears that the court omitted to take note of Section 59 and 65A dealing with the admissibility of electronic record. Section 63 and 65 have no applications in the case of secondary evidence by way of an electronic records. The same is wholly governed by Section 65A and 65B. To that extent, the statement of law on admissibility of secondary evidence pertaining to electronic record, as stated by the court in Nabje Sadhu case, does not lay down the correct legal position. It requires to be overruled that we do so. An electronic record does not lay down the correct legal positions. It requires to be overruled, and we do so. An electronic record by way of secondary evidence shall not be admitted in evidence unless the requirements under Section 65B are satisfied. Another very landmark judgment we got after the Bassi judgment came into effect, that is Tommaso Bruno judgment. In Tommaso Bruno judgment, the Honorable Court observed that with the advancement of information technology, scientific temper in the individual and at the institutional level is to pervade the methods of investigation. So investigations should take the electronic records, as the Honorable Court observed. With the increasing impact of technology in everyday life, and as a result, the production of electronic evidence in cases has become relevant to establish the guilt of the accused or the liability of the defendant. Electronic documents, stricto sensu, are admitted as material evidence. With the amendment to the Indian Evidence Act in 2000, Section 65A and 65B were introduced into Chapter 5 relating to documentary evidence. Section 65A provides that contents of an electronic records may be admitted as evidence if the criteria provided in Section 65B is complied with. The computer-generated electronic record in evidence are admissible at a trial if proved in the manner specified by Section 65B of the Evidence Act. Subsection 1 of Section 65B makes admissible as a document paper print out of electronic records stored in optical or magnetic media produced by a computer, subject to the fulfillment of the conditions specified in subsection 2 of Section 65B. Secondary evidence of contents of document can also be laid under Section 65 of the Evidence Act. PW 13 stated that he saw the full video recording of the fateful night in the CCTV camera, but he has not recorded the same in the case diary, as nothing substantial to be adduced as evidence was present in it. So another important thing which is going to come in where in the same judgment the Honorable Apex Court further observed production of scientific and electronic evidence in the court as contemplated under Section 65B of Evidence Act is of great help to the investigating agency and also to the prosecution. The relevance of electronic record is also evident in the light of Muhammad Ajmal Muhammad Amir Kasef versus State of Maharashtra case, wherein production of transcripts of internet transactions helped the prosecution case a great deal in proving the guilt of the accused. Similarly, in the case of State versus Nabje Sadhu, the links between the slain terrorist and the masterminds of the attack were established only through phone call transcripts obtained from the mobile service providers. Another very important thing about Tommaso Bruno judgment is that in the same judgment, the Honorable Apex Court observed that if the provisions of 65B and other evidences are not coming to the or the evidences which is relevant are not coming to the court, it is not a laches on the part of prosecution, but it is the entire thing should be interpreted in this way, that the best evidence was not been produced before the court. And in Sonu alias Amar versus State of Haryana, the Honorable Apex Court observed that the interpretation of Section 65B subsection 4 by this court by judgment dated 4/8/2005 in Navjot Sadhu held the field till it was overruled on 18/9/2014. In Anwar's case, all the criminal courts in this country are bound to follow the law as interpreted by this court. Because of the interpretation of the Section 65B in Navjot Sadhu, there was no necessity of a certificate for proving the electronic records. A large number of trials have been held during the period between 4th August 2005 till and 18th September 2014, and electronic records without a certificate might have been adduced in evidence. There is no doubt that the judgment of this court in Anwar's case has to be retrospective in operations unless the judicial route of prospective overruling is applied. However, retrospective applications of the judgment is not in the interest of the administration of justice, as it would necessitate the reopening of a large number of criminal cases. Criminal cases decided on the basis of electronic records to adduced in evidence without certificate have to be revisited as and when objections are taken by the accused at the appellate stage. Attempts will be made to reopen cases which have become final. In the Sonu alias Amar case, the prosecution has not come with a statement under Section 65B when the evidence was adduced, when the electronic evidence was adduced, and the defense remains silent. They have not put any kind of objection to that effect, and And when the matter went up to the appellate stage after the verdict by the lower court, then the same point was first time raised by the defense or the appellant, and the Honorable Court passed this order. So this is one of the case. Again, in the same judgment, the Honorable Court observed that this court did not apply the principle of prospective overruling in Anwar's case. The dilemma is whether we should. This court in K. Madhav Reddy versus State of Andhra Pradesh held that an earlier judgment be prospective, taking note of ramifications of its retrospective operations. If the judgment in the case of Anwar is applied retrospectively, it would result in unscrambling past transactions and adversely affecting the administration of justice. As Anwar's case was decided by 3-judge bench, propriety demands that we refrain from declaring that the judgment would be prospective in operations. We leave it open to be decided in an appropriate case by a 3-judge bench. In any event, this question is not germane for adjudications of the present dispute in view of the adjudications of the other issues against the accused. In this I already discussed about the factum of this Sanu alias our case. So the Honorable Court observed that being a 2-judge bench, it cannot override the Anwar judgment. But there is a huge issue that for those cases for which the investigating agency has not collected the statement under Section 65B, and after this Anwar ruling has come into effect, what will be the fate of those cases? Now, in one of the latest judgments we got in the year 2018 by the Honorable Supreme Court in Safi Mohammed versus State of Himachal Pradesh, the Honorable Court observed that electronic evidence was relevant to establish facts. Scientific and electronic evidence can be a great help to an investigating agency. Reference was made to the decisions of the court in Muhammad Ajmal Amir Kasab versus State of Maharashtra. Though in the Honorable Court further observed that though in Judge Bench judgments in Tomaso Bruno and Ram Singh, it can be safely held that electronic evidence is admissible and provisions under section 65A and 65B of the Evidence Act are by way of clarifications and are produced and are procedural provisions. If the electronic evidence is authentic and relevant, and the same can certainly be admitted, subject to the court being satisfied about its authenticity, and procedure for its admissibility may depend on fact situation such as whether the persons producing such evidence is in position to furnish certificate under section 65B subsection H. So, Honorable Court further observed that section 65A and 65B of the Evidence Act 1872 cannot be held to be a complete court on the subject. In Anwar PV, this court in para 24 clarified that primary evidence of electronic record was not covered under section 65. In Anwar PV, this court in para number 24 clarified that primary evidence of electronic record was not covered under section 65A and 65B of Evidence Act. Primary evidence is a document produced before court, and the expression document is defined in section 3 of Evidence Act to mean any matter expressed or prescribed upon any substance by means of letters, figures or marks, or by more than one of these means intended to be used or which may be used for the purpose of recording that matter. But the point is, electronic evidence in a primary format are seldom available, and that is the issue we're going to haunt us in the days to come. So, one of the landmark observation in the same Safi Mohammed case, the Honorable Apex Court further observed that the applicability of the procedural requirement under section 65B subsection 4 of the Evidence Act of furnishing certificate is to be applied when such electronic evidence is produced by a person who is in a position to produce such certificate, being in control of the said device and not of the opposite party. In a case where electronic evidence is produced by a party who is not in possession of a device, applicability of section 63 and 65 of the Evidence Act cannot be held to be excluded. In such case, procedure under the said section can certainly be invoked. If this is not so permitted, it will be denial of justice to the person who is in possession of the authentic evidence witness, but on account of manner of proving such document is kept out of consideration by the court in absence of certificate under section 65B subsection 4 of Evidence Act, which partly producing cannot possibly secure. Thus, requirements of certificate under section 65B subsection H is not always mandatory. So, an Honorable Court further observed that accordingly we clarify the legal positions on the subject on the admissibility of the electronic evidence, especially by a party who not in possession of device from which the document is produced. Such party cannot be required to produce certificate under section 65B subsection 4 of Evidence Act. The applicability of requirement of certificate being a procedural can be relaxed by court wherever interest of justice so justifies. In one of the latest judgment which we got in the year 2019, in this year, there was a issue being settled by this the ruling in this judgment, that is state by Karnataka Lokayukt Police Stations Bengaluru versus M.R. Hiramat. There was a issue coming up repeatedly. If the investigating agency does not collect the statement under section 65B from the competent persons when he is receiving electronic evidence from that person, whether that electronic evidence would not be admissible, and whether these defects is incurable, and there was another view is that even the statement under section 65B can be adduced at the time of trial. So to put this matter into rest, the Honorable Apex Court in this judgment has observed that the conversation between the complainant and the respondent was recorded on the spy camera. The factum of the case is that the evidence coming up without complying the statement under section 65B, and the on the investigated material after coming up, the accused filed the petitioner filed a squashing applications, and the honorable Honorable High Court has quashed the said case, observing the mandatory compliance of 65B, and against that judgment, this Honorable Supreme Court has passed this judgment. And in this judgment, the fact of the case that the conversation between the complainant and the respondent was recorded on spy camera, in the course of which it has been alleged there was some discussions in regard to the amount to be exchanged for the completion of the work. The first respondent then filed a discharge application under section 239 of the Criminal Procedure Code before the Special Judge Bengaluru. The trial judge dismissed the applications by an order dated 5th December 2016. This order was questioned in revisions before the High Court. The revision was rejected on the ground of maintainability. The respondent instituted a petition under section 482 of Criminal Procedure Code, which has resulted in the impugned order of the learned single judge dated 27th April 2017. The fundamental basis, the Honorable Court observed, the fundamental basis on which the High Court proceeded to squash the proceedings is its hypothesis that section 65B, which requires the production of the certificate for leading secondary evidence of an electronic record, mandate the production of such a certificate at this stage, in the absence of which the case of the prosecution is liable to fail. So the Honorable Court further observed in this judgment that the provision of section 65B came up for interpretations before a 3-judge bench of this court in Anbar PV versus PK Basir, interpreting the provision of this court held any documentary evidence by way of an electronic record under the Evidence Act in view of sections 59-65A can be proved only in accordance with the procedure prescribed under section 65B. Section 65B deals with the admissibility of the electronic record. The purpose of this provision is to sanctify the secondary evidence in the electronic form generated by a computer. The same view has been reiterated by 2-judge bench of this court in Union of India Others versus CDR Ravindra versus CDR Ravindra V. Desai. The court emphasized the non-production of a certificate under section 65B on an earlier occasion is a curable defect. The court relied upon the earlier decisions in Sonu alias Amar versus State of Haryana, in which it was held that the crucial test, as affirmed by this court, is whether the defect could have been cured at the stage of marking the document. Applying these tests to the present case, if an objection was taken to the CDRs being marked without a certificate, the court could have given the prosecution an opportunity to rectify the deficiency. So, in the same judgment, that is in Hirama's judgment, Karnataka Lokayukta judgment, the Honorable Court further observed, having regard to the above principle of law, the High Court erred in coming to the conclusion that the failure to produce a certificate under section 65B subsection 4 of the Evidence Act at the stage when the charge sheet was filed was fatal to the prosecution. The need for production of such a certificate would arise when the electronic record is sought to be produced in evidence at the trial. It is at that stage that the necessity of production of the certificate would arise. So that was one of the landmark judgment on whether the statement under section 65B even can be produced at the time of trial. Now, another very interesting observations by we got it in ICICI Bank Limited versus Gaurav and another case. In this case, as in a similar case in ICICI Bank Limited, in Kamini Sharma decided dated 31st January 2018 held in respect of filing original documents and statement of accounts as under Section 34 of Evidence Act clearly provides that the books of accounts maintained in electronic form are relevant. Under Section 62 of the Evidence Act, original documents consist primary evidence. In the context of electronic evidence, printouts of electronic documents are considered as secondary. However, judicial notice needs to be taken of the fact that most accounts today are not maintained in paper form but electronic form. The primary evidence could be the server on which the statement of accounts is stored. These servers may store the statement of accounts of multiple clients in the hard drives. It would be an impossibility to require the plaintiff bank to produce the hard drives of the server in every suit for recovery filed by it. Under such circumstances, the plaintiff bank has no option but to produce the secondary evidence, that is a printout of statement of accounts duly certified by a responsible official of the bank along with a certificate under Section 65B of Evidence Act. Needless to add, the certificate under Section 65B of Evidence Act has now become a usual practice in almost all of the suits, in as much as in every such suit parties are bound to place reliance on electronic documents. The mere fact that the printout is being filed as secondary evidence along with the necessary certificate does not make it any less valid. The said account statements would be rebuttable if any discrepancy is found or pointed out, but in the absence of the same, there is no reason as to why the statement of the accounts filed by the plaintiff bank should be disbelieved. And in light of these banking transactions, we got the amended provisions before the IT Act due to the influence of Information Technology Act, that there is an amendment in Bankers Book Evidence Act, and in Bankers Book Evidence Act in section 2 subsection capital A, we got subsection small a, small b, small c, wherein the concerned persons of a bank are to issue different statements in support of proving the e-ledger or online contract maintained by the computer system of the bank. So that is also to be kept in mind. If we compare the Indian Evidence Act, especially the section 65B with the section 69 of the Act in England, we see there are similarities between them, and the same has been imported in one of our landmark judgments. Is that in England this positive mandate was statutorily enacted, and prosecution had to show by positive and affirmative evidence that it was safe to rely upon the document produced by a computer from out of its memory. The Police and Criminal Evidence Act 1984 was enacted, but while interpreting section 69 of the said act, the courts took a practical approach and gave an interpretations where computer generated records could be proved by a statement made by an employee unfamiliar with the precise details of the operations of the computer, that the printout was retrieved from the computer memory and the computer was not malfunctioning. Section 69 reads as under: in any proceedings, a statement in a document produced by a computer shall not be admissible as evidence of any fact shall not be admissible as evidence of any fact stated therein unless it is shown a uh, small a, there are no reasonable grounds for believing that the statement is inaccurate because of improper use of computer, that all the material times the computer was operating properly, or if not, that any respect in which it was not operating properly or was out of operations was not such as to affect the productions of the documents or the accuracy of its content, and that any relevant conditions specified in rule of court under subsection 2 below are satisfied. Provisions may be made by the rules of court requiring that in any proceedings where it is desired to give a statement in evidence by virtue of these sections, such informations concerning the statement as may be required by the rules shall be provided in such a form and at such time as may be so required. So you see there are similarities between in a statement under section 65B and the mandate of section 69 of the England's Act. Foreign situations. In R.V. Seyfert, Lord Griffiths, dealing with the defense argument, held the principal argument for the defendant starts with the proposition that the store detective was not a person occupying a responsible position in relation to the operations of the computer within the meaning of section paragraph 8D of section of the schedule 3, paragraph 8D of schedule 3 of the act, and therefore was not qualified to sign a certificate for the purpose of providing proof of the matters contained in section 69 small a. This I accept, although the store detectives understood the operations of the computer and could speak of its reliability, she had no responsibility for its operations. I cannot, however, accept the next step in defendant's argument, which is that oral evidence is only acceptable if given by a person who is qualified to sign the certificate. The defendant does not go so far as to submit that evidence must be given by a computer expert, but insists that it must be someone who has responsibility for the operations of the computer, either the operator or someone with managerial responsibility of the operations of the computer. Documents produced by the computers are not increasingly common. Documents produced by computers are an increasingly common features of all business, and more people are becoming familiar with their uses and operations. Computers vary immensely in their complexity and the operations they perform. The nature of that evidence to discharge the burden of showing that there has been no improper use of computer and that it was operating properly will inevitably vary from case to case. The evidence must be tailored to suit the needs of the case. The evidence must be tailored to suit the needs of the case. I suspect that it will very rarely be necessary to call an expert, and that in the vast majority of cases it will be possible to discharge the burden by calling a witness who is familiar with the operations of the computer in the sense of knowledge that the computer is required to do and who can say that it is doing it properly. Statement by the witness that when the computer was working they had no trouble with the operations of the central computer was held sufficient in discharge of the affirmative burden. In DPP versus Mac, Lord Hoffman applying section 69 of the Police and Criminal Evidence Act in relation to the inaccuracy in the time display in the computer printout held. The purpose of section 69 therefore is relatively modest one. It does not require the prosecution to show that the statement is likely to be true. Whether it is likely to be true or not is a question of weight for the justice or jury. All the section 69 requires as a condition of admissibility of a computer generated statements in positive evidence that the computer has properly processed, stored and reproduced whatever information it received. It is concerned with the way in which the computer was dealt with, the information so generate, the statement which is being tendered as evidence of a fact which it states. The language of section 69(1) recognizes that a computer may be malfunctioning in a way which is not relevant to the purpose of the exclusionary rule. It cannot therefore be argued that any malfunction is sufficient to cast doubt upon the capacity of the computer to process information correctly. The legislature clearly refused to accept so extreme a proposition. What then was contemplated as the distinction between a relevant and an irrelevant malfunctions? It seems to me that there is only one possible answer to the question. A malfunction is relevant if it affects the way in which the computer processes, stores, or retrieves the information used to generate the statement tendered in evidence. Other malfunctions do not matter. It follows that the words not such as to affect the production of the document or the accuracy of its content must be read subject to the overall qualification that the paragraph is referring to those aspects of the document or its content which are material to the accuracy of the statement tendered in evidence. So it is giving some kind of relaxation to this strict rule. Now, the Law Commission in England reviewed the law relating to the computer-generated evidence. It summed up the major problem posed by rules of evidence by computer output in words of Stein J. It summed up the major problem posed for the rules of evidence by computer output in words of Stein J. Often, the only record of transactions which nobody can be expected to remember will be the memory of a computer. If computer output cannot relatively readily be used as evidence in criminal case, much crime and notably offences involving dishonesty would in practice be immune from prosecution. On the other hand, computers are not infallible. They do occasionally malfunctions. Software systems often have bugs. Realistically, therefore, computer must be regarded as an imperfect device. So experience has shown to us that development in computer networking, access, control, monitoring, and system securities are increasingly making it difficult for computer errors to go undetected. Most computer errors are immediately detected or resultant error in the date is immediately recorded. In a court of law, it would be impractical to examine the intricacies of computer functioning and operations. To put it in the words of the Law Commission report in England, determined defense lawyer can do cross-examine. To put it in the words of the Law Commission's report in England, determined defense lawyers can and do cross-examine the prosecution's computer experts at great length. The complexity of modern system makes it relatively easy to establish a reasonable doubt in a juror's mind as to whether the computer was operating properly. Bearing in mind the very technical nature of computers, the chances of this happening with greater frequency in future are fairly high. We are concerned about smoke screen being raised by cross-examinations which focuses in general terms on the fallibility of computers rather than the reliability of the particular evidence. The absence of a presumption that the computer is working means that it is relatively easy to raise a smoke screen. In USA, if we go and analyze the USA laws, it is a federal rule of evidence which is a counterpart of Indian Evidence Act, and the observation in State versus Cook, the court observed the process of mirror imaging or forensic copying and its methodology is admissible in the court. In Taylor versus State, the court recognized the importance of creating hashes to prove the data were not modified. So the very important, intricate, sophisticated cyber forensic evidence are acceptable by the court of law in two of these judgments. The law of assessment of electronic evidence in France. In France, as per the Article 384 of the Spanish Civil Procedure Act in Spain, the rule of assessing the electronic evidence, except in the case of a public electronic document, does not oblige the judge to have proof of the facts or data that the electronic records collects. For assessment of electronic records, two parameters of electronic evidence have to be adjudicated by a judge. One is the integrity of the content, and another is the authenticity of its origin. So these are the two hallmarks of assessing an electronic records in the law prevalent in France. So in some of other judgments, in Castle versus Cross, the court held that the printout was admissible evidence. In R versus Shefford, the court observed that so long as it could be shown that the computer was functioning properly and was not misused, a computer record can be admitted as evidence. In United States versus Barlow, the court observed that for electronic evidence, the witness providing such testimony may be persons who created the electronic document or maintains the evidence in its electronic form. In Lauren versus Markle, witness authenticating electronic evidence must provide factual specificity about the process by which the electronically stored information is created, acquired, maintained, and preserved without alterations or change, or the process by which it is produced, if the result of a system or process that does so. So it provides factual specificity about the process by which the electronically stored information is created, acquired, maintained, and preserved without alterations or change, or the process by which it is produced, if the result of a system or process that does so. So that we find there in the observation. Some other USA judgments are there. In V. Vinhe, we found that the court observed that a proponent must establish 11 steps, 11-step process for authenticating computer-generated or stored records, and they are: the business uses a computer is reliable, the business has developed a procedure for inserting data into the computer, the procedure has built-in safeguards to ensure accuracy and identify errors, the business keeps the computer in a good state of repair, the witness had the computer read out certain data, the witness used the proper procedures to obtain the readout, the computer was in working order at the time the witnesses obtained the readout, the witness recognizes the exhibit as the readout, the witness explained how he or she recognizes the readout. If the readout contains the storage symbol, or terms, the witness explains the meaning of the symbol or terms for the tier of fact. So we find this 11-step process for authenticating computer-generated or stored records. This is important. We find in rules 1003 of Federal Rule of Evidence that a duplicate is admissible to the same extent as an original unless a genuine question is raised as to the authenticity of the original, or in the circumstances it would be unfair to admit the duplicate in lieu of the original. So that we find in Rule 1003 of Federal Rule of Evidence. So it's about the a duplicate evidence going to be admissible. So finally, to conclude our today's discussions, I must conclude it in a through a enlightened philosophical observations in Penny versus Commonwealth, and the Honorable Court observes the potentially limitless application of computer technology to evidentiary questions will continually require legal adaptations. So, at the end of the day, the final conclusion would be that we are in the process of learning. The procedure, the process, the interpretations, the thinking, the perspective, the observations, whatever is coming up from different honorable courts in India and from the different honorable courts of the world judiciary is actually pointing towards the fact that we are learning, we are adapting, we are thinking, and we are in a process of maturity. We are in a process of getting maturity, and that's the crux. So thank you, friends. A little bit of detailed discussions on electronic evidence, 65B statements, and all been dealt with in this video. And I request again to you all, please subscribe to my channel. And this channel is meant for electronic evidence and cyber laws of India and other part of the world. So the law enforcement agencies, officers, the police personnel, the legal brothers, I think everybody will be benefited from my discussions in this video, and I'll obviously request you all, please comment in the comment below, and also like and share this so that the other people who may not be aware of this video should may get the opportunity to watch this video